times, to say the least. We will focus first and foremost on the situation in the Middle East, while also touching the events on Venezuela and how this is challenging international law. This session is part of the webinar series Better Be Prepared. My name is Iris Sayram. I'm a correspondent and lawyer, and I'm delighted to be joined by Professor Monica Hakimi, professor of law at Columbia Law School and co-editor-in-chief of the American Journal for International Law. And we have Professor Michael Kubiciel, professor for German, European, and International Criminal Law at the University of Augsburg. Welcome you both, and thank you for being here. So now, with no further ado, I may start with you, Professor Hakimi, just briefly to get an impression why many experts consider the US and Israeli attacks literally unlawful. What are the basic principles of international law, such as the prohibition of the use of force, national sovereignty, territorial integrity, and when it's maybe allowed to break those principles?
Okay, great. Well, thank you for having me, and thanks to all of our watchers for joining us. So the UN Charter sets the foundation for the post-World War II international legal order, and it provides that states are entitled to sovereign equality, and that each shall refrain from threatening or using force against the territorial integrity or political independence of any other state. And that has generally been understood to be a broad prohibition against any use of force by one state in the territory of the other. There are two exceptions to this in the Charter. One is for acts in self-defense, individual or collective self-defense under Article 51 of the Charter. And the second is with a decision from the UN Security Council acting under Chapter 7 to authorize the use of force in the territory of a member state. I should just add that the text of the Charter is on its terms pretty bare bones. And a lot of the practice on the use of force in international law over the decades since the Charter was adopted has been about essentially how to define the boundaries between, on the one hand, the general prohibition as it appears in Article 2.4 of the Charter, and on the other hand, the exceptions for Security Council authorization and self-defense. And I'll just note that the broader Article 51, the exception for self-defense, is interpreted, the more decision-making shifts from the territorial state or the collective institution of the Security Council to the states that claim to be threatened by some act in another state and want to use force there. So it's particularly on the parameters between Security Council authorization, the requirement for Security Council authorization, and the exception for self-defense that a lot of the debates have circulated.
Thank you very much. This is a lot to take in. Let's break it down a little bit, because you mentioned that Article 51, the right of self-defense, and how nowadays this is interpreted. Professor Kubiciel, can I ask you here specifically, would you say that the attacks on Iran fulfill the criteria of self-defense?
No, I won't think so, at least not under the standard interpretation of international law, because the threat was not that imminent that the attack on the missile bases and on the Iranian regime could be justified. I think the Minister of the Secretary of State, Mark Rubio, tried to plead that they had to act now because Iran was about to build something like a drone and missile shield, and within the next couple of months they would have had a missile and drone shield which would have granted them some sort of a military immunity against other or later attacks. But according to my understanding, that is not as imminent and does not fulfill the first exemption. And if I may add that I'm strongly favoring not to expand this exemptions, but to keep them narrow and do not add other unwritten and not acknowledged exceptions to this prohibition of the use of military force.
Thank you. Professor Hakimi, can I ask you here, what do you think of the other explanation Marco Rubio made? I think in the last week, he said that Israel was about to attack. So because of the backlashes from Iran to Israel, the USA had to attack first, so that we were in a kind of a preemptive scenario thing. Would you say that this is a good reason for the use of force?
No, I would not. I would agree with Professor Kubiciel about the parameters of the right to use force on self-defense. Again, although they are ill-defined and have been debated over the years, I think to justify this particular action as an action in self-defense would essentially eviscerate the parameters of the UN Charter and the role for the Security Council. And the logic that you just described is a logic that essentially would allow any state to claim the right to act in any circumstance in which any of its allies believes that it is under threat and requires some support or assistance to respond to the retaliation it's likely to get. So one problem with it is that it's not consistent with longstanding expectations under Article 51. A second problem is that if the law were to develop in this direction, it would eviscerate essentially the entire structure of the UN Charter.
There are two other arguments that are also in the debate. That is the nuclear program and also the problem with the proxies. So Israel's point of view is that Hezbollah and the Houthis and Hamas are claiming such a threat that it was allowed also to attack because of the Iranian involvement in those proxies. Is this a valid reason?
I would say probably not, but I think actually the more interesting or worthwhile question to be asking about both of these issues, the use of proxies to engage in massive violence in other states, or the development of nuclear capabilities and weapons capabilities in particular, is that international law has not done a particularly good job in assisting states dealing with these problems. These are longstanding problems. And both the risk of the further proliferation of nuclear weapons and the use of proxies across national borders in forcible ways. Both of these are longstanding issues. Both of them are issues that historically have been channeled through the various institutions and processes that law creates, including through the Security Council. But both of them are issues that I think leave a large number of states disaffected and disenfranchised. And so they're issues that require attention, even if not the particular attention that they're now being given.
Professor Kubiciel, would you agree?
Yeah, I would agree, but I would also add that I think that's a good reason that we do not include proxies or to be proxies as a justification to attack the states behind the proxies, because if you would do that, you have an infinite course of possible actions and military actions. Especially when you refer to the situation and the war in Ukraine, where the Russian government is sometimes arguing that the Ukraine government and military is some sort of a proxy of the Western community. And in other conflicts, there are states which are helping other military forces. So if we would have like a chain of proxies, allowing military acts on the center of this chain of proxies, we would get rid of the prohibition of war. That would be a very dangerous exemption.
Let's bring it to the other exemptions. What might here is maybe a reason to use force, and this is the responsibility to protect. Supporters of the war, or how some might name it, special operation, is that the Iranians, or the Iranian regime, better said, violated basic human rights, so that there was a reason to go in. We saw what happened during the protests in December and January, and that thousands of people are said to be killed. Is this something the US or Israelis can claim here? Professor Kubiciel, you're weighing your head.
Well, I would say that if that would be a justification, then at least the military design of this action must be capable of reaching that goal. And I don't see that these attacks are designed to lead to a regime change. I think these attacks have another purpose. They have another military aim. So Sean, alone from this deferred from this design, as I think that cannot be a justification, notwithstanding the question whether this legal thought is something valid and is something acknowledged in between the states and in state practice. That's, I think, something that my colleague Hakimi can say something to this point.
Okay, well, I would just add that the idea of the responsibility to protect, and in particular that the responsibility to protect entitles a use of force not otherwise authorized by the terms of the Charter, that it is yet another exception to the two exceptions that I mentioned earlier for self-defense and Security Council authorization. That idea is itself very controversial, and it is especially controversial among states of what are sometimes called the Global South. Because the fear was, as R2P was especially prominent, that it would be used as a justification for regime change. And after the Libya intervention of 2011, I think a lot of the wind in the sails behind the idea of R2P got lost because that regime change was viewed to be so problematic.
You mean Libya, Gaddafi?
Yeah, Libya, sorry.
Yeah.
Yeah. So I would just add again, though, what I said before, which is that international law does not have especially good answers to the question of what to do when a state commits mass atrocities or human rights violations against its own people. And further, that channeling that question through the lens of the use of force makes it harder, not easier, to resolve what should be done in these circumstances. So these are sort of long-standing issues that are now, like the question on proxies, like the question on the nonproliferation of nuclear weapons, are sort of boiling over in this context. And even if they're boiling over for reasons that are pretextual, they're exposing what have been long simmering issues under the pre-existing legal system.
You mentioned the Global South, and I think this is a very important point because they are often, very often, are saying that the West has some kind of double standards and that they are using international law like it fits best for them. I remember the speech of the Canadian Prime Minister Carney in Davos. He said he had this analogy with this sign in the window from a Václav Havel speech, which was very impressive. And would you say, do we have double standards then in international law?
I would say that yes, that historically different states have not always stood by the principles that they claim to espouse. I would say that's true of the United States. I would say that's true of many European states. And I'd say that's true of many states that identify as being in the Global South. So this is an issue in the law and politics that operate on a global level. I will say that I think one thing that this framing misses that is maybe useful to bring to light is that this particular sort of double standard question is not new. What is new is that the United States, which has historically done a lot, not just to play fast and loose with some of the rules, but also to uphold many of the systems and institutions and structures of the international order, is both playing hard, fast and loose with the rules and withdrawing its support from those institutions and structures. And in my view, it's the latter that is ultimately more destabilizing than the former. And the former, the playing fast and loose with the rules, is becoming exacerbated by the fact that the United States is no longer willing to uphold the basic structures of this legal system in the ways that it historically has.
I would like to add.
Yes.
I would like to add that I don't think that there's like a black and white picture, such contradiction between the view of the global South and like so to say the West. Because if you look at the situation in Venezuela and now in Iran, the assessment was different because Western scholars were complaining about the arrest of Maduro. My colleagues in Germany were complaining about the violation of international law in view of Iran. But when I speak to my colleagues in South America, with what I do quite frequently, they told me that the population there was very much in favor of getting Maduro out of the country because they are all suffering under the consequences of his regime down to Chile. And so the international law objections weren't that relevant in that case. And I would bet that the majority of the Iranian people would like to have to get rid of this regime. And although this would violate standards of international law, so it's the social reality and the perception forms the perception of law and the perception of the importance of law. And so I don't think that we can outplay the Western view on international law versus the Southern view on international laws. Oftenly more more ambiguous and more complex, I think.
I just want to take the chance to make a remark that I forgot in the beginning. You are entitled to ask questions, so please don't hesitate. If you have anything, I try in the last part of the session to pick a few, and so bring your thoughts also into the debate. Professor Kubiciel, you just said that, yeah, maybe many peoples in Venezuela, for example, or also in Iran, we saw so many protesting on the streets, would like to get rid of their leadership. But the question remains if this should be with the meddling from outside, with bombing different foreign countries, with the very volatile situation we are seeing here right now, that the backlash could be spillover to a very big regional conflict or even war. So that brings me to the next question. I would like your thoughts on that. Is Iran then now entitled to pull Article 51 for self-defense? So can they do what they are doing right now? Is this legal? Silence. Who would like to go first?
I'm happy to go first. I think most would say that although Iran is entitled to use defensive force against Israel and the United States, it's not entitled to the broad use of force across the entire region and even beyond the region. And the reason to constrain the use of force as between the states that are actually involved in the fight is to prevent the metastasization of the violence and the possibility of a regional or global war.
Professor Kubiciel, would you like to add something?
No, I completely agree with that. As long as Iran defends against the attacks of Israel and US and does not strike Dubai city or other cities, they act in accordance with international law. Simply because international law is a system of states and of a system of states, and this system does not question or does not evaluate whether the regime representing the state is some sort of legitimate or just or democratic. It's a coordinating mechanism between abstract forms that we call states and the concrete substance of the state, whether it is democratic and obeying to the rule of law and so on, is not as so much a central question, which is sometimes disturbing for lawyers in the West or for the citizens in the West who are not aware of this thing, I think.
So the argument of the Iranians are that they have military bases in Qatar and Saudi Arabia, and so that they are part of, kind of part of the Israeli and US side. So, but you would say this is not a good argument for using force against those states, just for a clarification.
I would say it's a closer question where the use of force is directly targeted at a military base in another state than where the use of force is targeted outside the military base in the territory of those other states. So I think it becomes a little bit of a harder question, although, and I think international lawyers would debate that question. I think I would also just like to maybe expand the frame a little bit and suggest that these questions about when the use of force is or is not lawful, these questions, as I said, as I sort of intimated at the beginning of our conversation, these questions are often debated, although maybe less so in the current context. One thing that is remarkably different about this war relative to others is that there are very few actors who are explicitly engaging with the discourse of international law to define the terms based on which they are acting, and they're certainly not using the procedural and institutional mechanisms that they have historically have done to be transparent about what they're doing, to offer reasons that are grounded in reality and fact, to respond to counter arguments. These are basic public law virtues that the practice of international law has historically offered, even where there have been violations. And I think the fact that we're not seeing more of it is indicative of a deeper crisis in the international legal system than any particular argument or any particular war would reveal. And so it's that deeper crisis to which I think those who are concerned ought to spend more of their attention, focus more of their attention, and maybe less on the specific arguments that are made by one side in this conflict or another, half-heartedly and often without good support or full reasoning or responding to counter arguments.
I would like to bring in the current escalation in the Strait of Hormuz. President Trump asked the certain countries and allies to come and help with military. Do you think this is something also the Germans should engage in, or should they stay away from it because there is the risk of getting dragged into this conflict? And why doesn't he pull Article 5 of the NATO then here?
If I may answer or start with answering, I think that's a really big problem for the German government because on the one hand, we have the military capabilities to help there. We have
Do we have them?
Yeah, we do have them. We are specialized in minesweeping because of our Baltic Sea. And according to my initial interpretation of international law, I think it would be in line with international law because that is not an aggressive use of military force, but something defensive to sweep mines in the Strait of Hormuz and enable the free passage of vessels there. So I don't think that international law would be some sort of like a trump card prohibiting military assistance by the German Navy. And the other thing would be the constitutional question. In Germany, we have a parliamentarian army. We cannot send our troops just on the order of the president or the chancellor outside of our borders. And I think it would be rather hard for the German government, for the two parties to find a majority in the Bundestag.
Can I just have a question here? Because you said it's for the defense, it is okay under international law. But would this incline the involvement of the German parliament also for defensive measures or only for others?
No, I think the question is whether that is an out of area mission. And as long as we send our troops out of our European and NATO theater, we need a parliamentarian approval for that. And at least, and even if it's not a constitutional question, I would doubt that Chancellor Merz would do this on his own responsibility and on its own cost. He would definitely ask the Bundestag, and I doubt that that would be very easy to find a majority there. And Germany can do it technically. They can do it, I think, international legally. So, and how to act now. And that's, I think, a political problem for the German government.
Professor Hakimi, you just mentioned that the mechanism of international law and the UN Charter aren't met here, that more or less are left out by the participants. Would you say that that pulling an Article 5 NATO treaty is also a sign that that Trump called it a test of loyalty if the allies would step in and help? He doesn't take the norm in the treaty. Is this also a sign that he doesn't care about international treaties and international law at all?
I think it's a sign that he doesn't care about the formalities of law, which is true both internationally and domestically. And of course, I would not be so presumptuous as to suggest a path forward for Europe in the current situation. I think it's in a very difficult situation. I will say, though, that I think both among Europeans who are deeply distressed by the destructive tendencies of the current US administration and among Americans who are deeply distressed by it, of which there are many, there has not been, I think, to the extent that there needs to be, a full-throated articulation of what it is one wants to preserve and how one goes about preserving that. It's clear and what compromises, given that we are inevitably going to see changes in the future order relative to the past one, given the changes that the United States and others are insisting upon. So I think it would be very helpful not just to ask the question, well, should Germany send troops to or engage in minesweeping in the Strait of Hormuz, but what position actually is Germany and Europe more generally seeking to take in what is increasingly a global conflict, sometimes kinetic, sometimes not, that is designed to and is in fact going to change the future trajectory of the world? What position actually would Carney like to take when he says we're no longer going to take the position that we historically have? And I think that's a very difficult question to ask. I think it's a question that will require intense compromises based on the expectations of the old system, but a question that really requires more sustained attention.
So doesn't leaders like the German chancellor, for example, have to speak up more, like the Spanish MP Sanchez did 2 weeks ago? Because international law is kind of treated like an esoteric academic debate. So do you see that the politics, if they are not defending international law, are maybe drifting away from the power of law to the power of the powerful, the strength? Do you know what I mean?
Well, I don't see that the German government derives or neglects the importance of international law. What Chancellor Merz has made very clear at the Munich security meeting there a month ago, that according to his opinion, the social reality of our international order has dramatically changed. And one very famous international lawyer, Wolfgang Friedmann, once said that whenever the international relations change dramatically, this must have or will have impact on the application of international law. And what derives from that? Merz told his audience that the German foreign policy would both refer to the interest and the values, and that we would defend both. And sometimes you have a conflict between values and interests. And I think in the case of Iran, it was very good for Merz not to lecture Trump on the international law, because other did that, and Germany did not say that there was a justification for this attack. But for more or less tactical reasons, I think it was quite clever to play with different roles within the European Union and get Friedrich Merz, the Chancellor of Germany, the part who is a little bit more reluctant, like compared to Spain and even the UK.
I have here a follow-up question because I can understand this is the position of Friedrich Merz now with the recent attacks, but we experienced other attacks last year in June. I think it was called the Midnight Hammer or Roaring Lion from the Israeli side when the nuclear sites in Iran were bombed. And this only per se can be seen as being an illegal attack. And Chancellor Merz called it Drecksarbeit, so the dirty work. So did he encourage, with this kind of framing, maybe the actions we have seen now almost 3 weeks ago?
I don't think so. Wouldn't Israel and the United States, haven't they act if Mr. Merz would have find a phrase a little bit more careful and balanced? I don't think so. I think that he is pointing on a basic factor of reality. In the last decades, not to say the last centuries, international law was always a law which was a little bit imbalanced. We spoke about that. The middle-sized and small countries do comply traditionally with international law, and the great powers do not do that so often. They do it more than compared to the 19th century. But whenever it is in their national interest to launch, for example, a military attack on a country to protect themselves or their allies, they do so even without an international legal foundation. And I think we have to be aware of this reality, and everything else would be naive. And so international law for a politician in the position of Chancellor Merz and the European Union cannot be, I think, now absolutely obliging norm, like a trump card in the Dworkin sense that overrules any other political aspect. But it has to be balanced, and it has to be used wisely. Sometimes you have to outcry and complain about it and make it public. Sometimes I think it would be more wise to be a little bit more indirect and tell it behind closed doors. And in the case of Israel, we have a special relationship with Israel as Germany. So I think we are not in the phases of legal nihilism or Realpolitik at its most dirtiest forms as far as the European Union is concerned. So I would not over-exaggerate that.
What thought did you think, Professor Hakimi, when you heard Chancellor Merz call this a dirty work?
Well, I guess I disagree with a number of things that Professor Kubiciel just said, so this might be a useful way finally for us to find our points of difference. I think, first of all, that there's no basis for saying that great powers don't comply with international law when it goes against their interests. In fact, we have no way of knowing whether they do or they don't. Because when they comply, it can be chalked up to they do it for reasons consistent with their interests, and when they don't, you can just be chalked up and say like, oh, well, it must be against their interest. And so that frame, I think, is a misdiagnosis. It's unsubstantiated to the extent it's true. The second thing I would say is I also don't think it's true to say, or sufficiently accurate to say, that where, for example, the United States used its military power inconsistently with the black letter law of the UN Charter, it did so because it decided that doing so was consistent with its purely nationalistic self-interest. In fact, many of the circumstances in which the United States used its military force in ways that pushed the boundaries of or exceeded the terms of the Charter were instances in which other states were pushing it to act. And often, I mentioned the Libya case, Libya 2011 intervention earlier. That was a case in which the US government, the Obama administration, started out actually predisposed against. And it was with the push of other actors in Europe and in the Middle East that the United States decided to get involved. So it's not quite right to suggest that states use military force inconsistently with international law for their self-interest, as distinguished from their interests that are created in part through their interactions with other entities, including their allies. And so here too, when you ask the much more specific version of this, did Germany in some way acquiesce in the use of military force by Israel and the United States against Iran? I would say in broad strokes, Europe has been on board with efforts to constrain Iran's and limit Iran's acquisition of nuclear weapon capabilities. And it has been more or less in line, but never completely out of line with that basic goal. And that language that you quoted, oh, well, Israel is doing our dirty work, is a reflection of what is actually the reality, which is that the interest in trying to prevent Iran from acquiring nuclear weapons is an interest that many share, and that the United States and Israel historically have been most assertive in trying to advance, but have not advanced to the exclusion of other entities, or even entirely to the exclusion of the international legal system. Of course, the United States worked hard through the IAEA and the UN Security Council to impose on Iran and to insist that others impose on Iran a comprehensive set of sanctions that then led to the nuclear deal in the first instance. So this is all a way of saying that I think one has to understand US behavior not just as a manifestation of its internally driven self-interests, and especially when it acts inconsistently with or pushes the boundaries of international law, but as a reflection of a set of interactions that occur both domestically and internationally, and that have over the years actually facilitated US behavior that many on some level support, even if they don't support the final decision to use military force to try to accomplish the end goals. And that is actually the reality of the world in which we once lived. And we're moving toward a different reality in which the United States is no longer interested in working as closely with its historic partners to define what it's going to do and what its own interests are, that it is going to focus much more on some internal sense of what it needs and an internal sense of its demand for dominance, especially in its contest against Russia and China and Iran, that is disconnected from what many of its allies see as in their immediate self-interests. And so that is the change that we're seeing, that I think the paradigm of, oh, powerful states will always be powerful and will always disregard the rules, papers over and fails to fully bring to light.
I would like to dip a little bit deeper on one thing you just said. You mentioned that Europe was also in line, that the Iranians should not have this threatening missile program. You said in the beginning, or you set out the main principles of international law, and you spoke about the territorial integrity and sovereignty. Isn't it also a part of a sovereign state to have a missile program? Because we know that a nuclear program under the Non-Proliferation Treaty is only for civil purposes allowed, so not for military purposes. So this is crystal clear. But when it comes to the missile program, it gets a little bit blurry because, I'm very interested what you say. Are the Iranians allowed to have a missile program, or are they in breach of any international, I don't know, contract or norm that I'm not aware of?
I would say that there's nothing in international law that specifically precludes Iran from having missiles, that as international law, as Iran is a party to the Non-Proliferation Treaty on nuclear weapons, it is prohibited from acquiring or proliferating nuclear capable missiles or nuclear ballistic missiles, nuclear weapon technology, let's say, nuclear weapons, let's just say, to put it in the simplest terms. And I think that nuclear non-proliferation regime is unfair. It is built to be unfair. It, on its terms, separates nuclear weapon states from non-nuclear weapon states and imposes different obligations for each. So it's not a fair system, but it's a system that I think, despite its inequities, many would say has served humanity well by reducing the risk of the proliferation of nuclear weapons And historically, it has served humanity well, in part because the United States has been really, really strongly behind the non-proliferation of nuclear weapons, at least with respect to its adversaries. And that is now, it has now overstepped sufficiently and in enough places that it's no longer able to maintain the line like that it once did, and that it is no longer interested in doing so. So the issue is that we are likely to see a proliferation of nuclear weapons, and we are already seeing reduced controls on the development of nuclear weapons. And with the proliferation of violence more generally, the democratization of violence more generally, and the use of proxy groups, we're also likely to see an increase in the risk that nuclear weapons will be used. So that is actually the issue that warrants considered attention, even if we focus on the question of, well, Iran should be entitled to develop ballistic missiles, right, for its own defense. It shouldn't have to sit like a sitting duck waiting to be attacked anytime some other state disagrees with the decision that it makes internally for its own self-governance.
Professor Kubiciel, you just mentioned the special relation Germany has to Israel, which is no question about it. I found a General Council resolution. I think it's 10 years old, and in this resolution, it was said that also the Israeli might be a part of the non-proliferation treaty. That would be a step forward, and that they also should put their arsenal under the EIEA control. What do you think? Is this okay to treat Iran in a certain way, but Israel is allowed to have a nuclear program?
Well, that's not a legal question, but it's a political question or a question of fairness or justice, so to say. But I would say that the difference between the Iranian program and the Iranian army and the Iranian efforts to build a huge capability of drones and missiles is that Iran aims at annihilating Israel. At least the regime wants to do that. And they have taken action. They have later some sort like a ring of fire with terrorist organizations around Israel. They have proven to do so. And when we are speaking political and we are speaking on matters of moral or justice, I don't think that you can say it's a matter of fairness to give such a regime a nuclear weapon because Israel has a nuclear weapon. And for Israel, a rather tiny state, I think the nuclear weapon is the measure, the instrument of last resort. I think that's guarantees their survival. Whereas for Iran, a nuclear weapon could be an instrument of attack. So I think politically and morally that cannot be compared.
There's a question from the audience. We moved forward from the Strait of Hormuz issue, but I would like to make this point from Friedbert Meurer, because this is a very interesting question. He asked, wouldn't a German participation in minesweeping really be legal? This would mean a military coordination with the US. I don't know if this is true, but what are your thoughts on that?
Well, it depends when the minesweeping will start. Would it start during ongoing military attacks of the US, or will it start after the ceasefire or so on? That would be a decisive matter. But even when the German Navy would start adopting defensive measures like the sweeping of mines in an ongoing conflict, in order to enable vessels the right of passage through the Strait of Hormuz. I think that would be legal, even when they would coordinate that with the US military command, and even when that would be necessary for American ships or other ships to sink Iranian Navy ships trying to attack the German minesweepers.
Thank you. Professor Hakimi, you just mentioned before the lack of including the United Nations instruments, mechanisms like addressing the Security Council before an attack, or seeking a resolution for a justification like Article 51. But here we are. This is the situation. What can we do about it?
It's a really good question. I was suggesting earlier that I don't have a good answer to the question. I'll tell you what I think are not good answers. The not good answers are do nothing and just let the moment pass by without thoughtful, concerted action, and not to insist that the world as it once existed be somehow reinstated, including the law and the legal system as it once existed, be reinstated. I think neither of those options is practically available to us. And so the thing I've been trying to encourage international lawyers to do, and I don't feel like I can single-handedly do this, but is to be clear about some of the compromises that will need to be made between the legal principles that we have come to take for granted and the future that we confront. So, for example, I mentioned earlier that international law has never had really great or satisfying, in my view, answers to the question of what to do when a state commits atrocities against its own people and will not stop. That's been a longstanding question. And the doctrinal answer, the formal international legal answer, is to prioritize, because of the concerns about the use of force, the interests of the territorial state over the interests of the people in that state. R2P effort reflected an effort to push back on that. And the debates about R2P and the resistance to R2P reflected an effort to maintain it. So now the question is back in force in a number of contexts. Should everyone continue to insist on preserving the territorial borders as they were established at a particular moment in time, or particular moments in time, and insisting on the political independence of the entities that operate in those borders? Or is it time to construct something new? I am on record as saying, yes, we need to maintain those borders because a territorial free-for-all is a recipe for disaster. And then the question becomes, okay, so how do we harness the support for that very basic, very core norm? What forces need to gather around behind it? What alliances, what coalitions, what forms of normative and material support, if you want to put it in that way, need to be collaborated and put together to say, the thing we will not do is we will not remove people from the territories to which they are now entitled, and we will ensure that they have some self-governance within those territories, even at the cost of many of the other things that we might also prefer to have happen. And we are willing to support this in the following ways and across the board. So not just in Ukraine, but also in Western Sahara and in the South China Sea and in the occupied Palestinian territory and in Cyprus and in Cuba, and we can go on and on in Somalia. So we can go on and on. We can identify the various states that are very fundamentally at risk where that norm is no longer supported. And so that's where I think we should focus our energy. It is very, very basic. It is very, very fundamental. But I think without that norm, we're likely to see much, much more devastation and destruction at a scale that we have not really seen since World War II.
Allow me to be a little bit more specific and point on the European and German side. Professor Kubiciel, you are, I know, an expert on enforcement and law enforcement, and this is the key, maybe that is missing here. And there's no mechanism to enforce the international law, but we have courts. We have the International Court of Justice, and we have the International Criminal Court of Justice. But we see, for example, in the case of the ICC, the International Criminal Courts, the warrants against Netanyahu for his actions in Gaza, that even the German government is struggling to enforce the warrant when the going gets tough. And isn't this a little disappointing, given the fact that Germany was or played a very important part in funding and building this very special court, and also we are bound to the international law by our constitution. And shouldn't we do more here? Maybe also think about sanctioning countries who are not in line with international law. Would this be a thing maybe to get over the situation that no binding resolution in the Security Councils can be reached because of the veto power of the 5P?
Well, first of all, the good news is that international law and international criminal law is still alive, and the ICC is not moribund and it's not dying; it's still vivid. You can see that for example, they finally started an investigation with the situation of Afghanistan post 9/11, which includes also U.S. institutions like the CIA and even U.S. citizens, which led to a great deal of anger by the Trump administration. And another sign is that the arrest warrant of Netanyahu. Whether this is completely correct, these accusers, I cannot tell you, but
No, that's not the question. Yeah, right.
Yeah, it's in the world, and it has effects. Although the debate you were referring to today, until today, he hasn't come to Germany, and I doubt that he will land in Berlin. I know that there were initial think that the politicians were thinking about different scenarios, inviting him to a U.S. airbase or to an extraterritorial part of Germany, to an embassy or something. But this shows that the space for Netanyahu has been much smaller, and I think the arrest warrant works. And despite of the debates that it can't be that a German military officer arrests the Prime Minister of Israel. And sanctioning countries like South Africa, others who would not work or would not deal accordingly with the arrest warrant, I think that's again a political question. And what would be the consequence if we would sanction such countries like South Africa? What would they do? Would they leave the Rome Statute? Would they cease their cooperation? Is that a wise step to do? I would be very careful to give that advice.
Professor Hakimi, do you have any thoughts on maybe putting a sanctions regime here in case that a country is in breach of international law?
I am not opposed to a sanctions regime in cases of breach, but I generally think that international lawyers and the public at large focus too much on questions of enforcement and enforceability and not enough on questions of support. Because ultimately what makes international law work is not that it is enforced without relief against those who violate it, but that enough people support it enough of the time that they are willing to work within it and use it and implement it. After all, international law is a law that is principally focused on states, and it's a law that is designed to help states do things that they want to do. And so to focus on enforcement is to imagine a world in which international law is doing things that states generally do not want to do when enforcement becomes such a massive problem across the board. And then one should ask the question, well, if states generally are not on board with this enterprise, should it change and be more responsive to them? And how can it adapt to harness more support for it? And so I would say that the focus on sanctions and enforcement is a thirst for international law to look like what many think a state domestic system ought to look like, when in fact we don't even want a state domestic system to be so draconian and enforcement oriented. And that's sort of my hesitation with focusing so intently on questions of enforcement, which I think is where the field tends to go too easily.
So maybe like more thinking about kind of soft powers that we combine trade agreements with international law, that we are, I don't know, lifting tariffs for certain countries when they are in line of international law? Or is this naive to ask, Professor Kubiciel?
No, it's not naive, because when you're making a political deal, you can combine things that are not on the same level. So you could combine, for example, these things you mentioned. But I think what is even more important is that the Western world, at least the European Union, should not refrain or put it back to international law. I was talking about sometimes it appears like a mantra, the referring to international law, but a mantra has a good side, because the reiteration, the repetition, holds up the awareness of the importance of international law, and as a result, it might sink in the international policy discourse and have action there. So we should keep on talking about the importance of international law, the great adventures and advantages that it brought to the world. When you compare the world today with the world from 200 years, you will find out that that the ratio of wars has sunk dramatically. You have very, very few wars compared to the 19th century, where we didn't have that international law. So we have to speak about it. But, and that would be my plea, we have to grant politicians, which I think are on the good side in the European Union, some sort of discretion how and when to make that point. We scholars can and shall refer to international law every time we were asked in newspapers and articles, in Zoom conferences. But I think it's wiser for Friedrich Merz and the Belgian government to adopt to a little bit more tactical approach to that.
I have one more last question from the audience, which I think is a very good wrap up and a short one maybe. How do you rate the effectiveness of the UN or the Security Council in responding to the Iran war? Would like to go first, Professor Kubiciel?
The effect of the UN Security Council?
Of the UN and the Security Council.
I think
so how effective are those?
Well, the effectiveness of the Security Council is more or less zero, but the UN is more than the Security Council. There's the General Assembly, and they could adopt a resolution and overrule some sort or circumvent the veto right of the United States, as the General Assembly of the United Nations has done in view of Ukraine and circumventing the veto right of Russia. So if there's a good and great amount of states coming together in the General Assembly, they could adopt a resolution criticizing the use of force in Venezuela and Iran. That is so that there's efficiency or potential for efficiency, I would say.
That's interesting. I almost forgot that. Yeah, that's true. Professor Hakimi.
I would just add that the Security Council has adopted a resolution on the situation in Iran, and it was a remarkable resolution.
Yes,
because it was reflected, in my view, the changes that we're seeing in the legal system and the political system, and not simply a reassertion of the law as it once was. It was a resolution that essentially condemned Iran for attacking the Gulf states without any reference to the behavior to which Iran was responding. And that is remarkable because one cannot imagine the Security Council adopting that resolution even 3 years ago, 5 years ago, 7 years ago. It's a resolution that essentially deprioritizes Iran as a state entitled to certain prerogatives relative to the surrounding states that were able to get that resolution passed. And so I would recommend to our viewers that they read the resolution and they read the readout of that resolution, in which it was made clear that Russia circulated a different resolution.
In China, I think, both of them. Yeah.
And China supported it. And it was a resolution that would have said that the rule applies also to Iran. And that resolution failed, not just because of the US veto, it failed because only 4 states were willing to support it. That's a dramatic shift. And it's a shift. And so here the Security Council is extraordinarily effective at reflecting and providing a sort of a guidepost to, or a map to where we might be heading as a world. And if that's troubling, then one ought to look at it as a sign of where things are moving and try to find ways to move it in a different direction.
That was really a remarkable session, and I would recommend everyone who is listening here to watch this on YouTube. I think it's only two hours long, but it's really interesting how the different countries are arguing here. So the 60 minutes are over. Let me wrap it up a little bit with a tiny quote I just recently found in a very good book. It's from the first UN Secretary, Dag Hammarskjöld. I mean, he was not the first, but one of the first. And he said, the United Nations was not created to take mankind to heaven, but to save humanity from hell. And I find it somehow very on point when we are talking about the situation nowadays. I would like to thank everyone for taking part into this debate, for listening, and especially to Professor Hakimi and Professor Kubiciel. And yeah, tschüss and take care.
Take care. Bye-bye.